We really only have time for one question, but I think it's a very important one, and I want to put it to all the justices, and it's based on something that Lord Dyson said in his talk. He talked about purist lawyers and a purist view of law. And he said that under a purist view of law, purist justices in a domestic context could probably not have done what was done at Nuremberg. So I want to put to you, to each of you, whoever wants to answer, one particular problem that grew out of Nuremberg. So the indictment at Nuremberg included the killings at the Kirten forest. And the people who were charged with doing it were the Nazis. The Nazis' defense was very simple. We didn't do it. You did, pointing to the Russian judge. He was 100% right. The Russians did it, and they planted evidence to make it seem as if the Nazis did it. And the judges got together with the prosecutors, and they all agreed to quietly let the matter drop so that the Nazis were no longer being charged with a crime that the Soviet Union had committed. But the Soviet judges were sitting in judgment. So my question, I'd like to put it to Lord Dyson first because he raised the question of the purists. If you were a judge at Nuremberg, would you have allowed the matter to rest there? Would you have allowed the implication to remain that although the Nazis didn't perpetrate that horrible massacre, that maybe we don't know who did it when you fully knew that the government represented among the four powers that were in the court was responsible for that very crime in the indictment? Well, let me give you.
Well, if I knew, then I don't see how I could. But I'm not sure that on the facts that it was known at the time when the Nazis denied responsibility for the Katyn massacre. And I think they did point, as you say, they pointed the finger of blame at the Soviets. But that wasn't known. And it may have been, is your point that the Soviet judge knew?
I'm a law professor, so I'm allowed to give you hypotheticals.
Okay.
Hypothetically, what if Roman Rudenko, the prosecutor, or Smirnov, the judge, were aware that this was a Stalin-inspired murder and cover-up, and you knew that they knew, but because you wanted to achieve imperfect justice rather than perfect injustice, you might have to continue to allow that false charge to remain in the air. Could you, as a judge, you think have remained silent?
Well, that's a very personal question. I personally couldn't have allowed that to happen because that I would be, I don't know what oath a judge on that court takes, but I'm assuming that some sort of oath would be taken, and it would be something similar to the sort of judicial oath that I took a long time ago as a judge in my country, and that I couldn't have contemplated doing that, consistent with my oath.
Well, I think that's a great answer, and I'd be interested in any of the other justices. We can expand it a little bit. Even assuming you didn't know about the Katyn massacres, certainly everybody knew at that point that Stalin and the government represented at the court had perpetrated massacres in the Ukraine starvation, and the court agreed not to allow a defense of dirty hands. Now, dirty hands is generally not a defense allowable in any event. If a person is being prosecuted for a serious crime and he has evidence that the prosecutor has committed serious crimes, that's not a defense. You might seek to recuse the prosecutor or something of that kind. But how generally, Justice Beinisch, for example, would you deal with the question of imperfect justice? And let me put the question more directly to you as Israeli. Israel has been subject to imperfect justice, to the kind of argument that says, well, you know, sure, there are other governments that engage in these kind of horrible crimes, but we're going to sit in selective judgment on Israel. Better to do imperfect justice against Israel, for example, by condemning it for building a security barrier by a judge, the Chief Justice of the International Criminal Court, who condemned Israel for building that security barrier, was involved in the Chinese Communist Party's decision to build 100 or so fences much like that in Tibet. And so you have the claim of utter hypocrisy and double standard, and the justice might respond by saying, look, we're not talking about China here. We're talking about Israel. We're sitting in justice on Israel. That's good enough. Would you accept that?
No. What I try to say, and this is one of the reasons, I think we need, a judge should have one commitment to the truth, to the moral values, and this is the flaw of international law, when you have judges that are really involved. I mean, if they have their own, and they are not a prosecutor, they're a judge, and they can't stand anything which would be in contrast to their commitment as judges. You mentioned before, and I think this is what's so great about our system, that people like our President Barak, that was a survivor, could sit in the Maniuk's trial and acquit him. Not because he's such a right person, but because we have our rules of law, we have due process. He wasn't indicted on the same crime, so he couldn't be convicted knowing that he releases a criminal. Mm-hmm. So this is part of the way judges should think. That's why I don't know how, I don't have the solution, but this is why I think court should be independent, not dependent in countries, in politics, in the background, a political background. And this is the flaw. The Nuremberg trial, after all, wasn't a regular trial. It was the first time, and it was by the people who really won the war, which was a good idea to have the trial. But yet, it's not a perfect trial from the point of view of jurists.
Justice Rugege, obviously, in the trials that you talked about, you mentioned that you didn't think it was victor's justice. But nonetheless, isn't there the risk when you permit for imperfect justice, when you permit for compromises, that you might get a politicization? And from your experience in Rwanda and in Africa in general, do you think it's possible to apply the kind of single standard of justice that both Lord Dyson and Justice that we're hearing about now? Do you think that's possible based on your experience?
I think that, as you say, there might have to be compromises. In the specific case of Rwanda, with respect to Gacaca, as I said, we were using lay people. We didn't use lawyers, either as judges or prosecutors or anything like that. We had 1 million people to prosecute and over 1 million people to give justice to. You can't do that through the normal conventional judicial system with all the safeguards of due process. So you have to choose either to let them go and have impunity on a large scale, or you make some compromise of having the people themselves decide whether the truth has been told, and therefore they convict somebody and punish him. And that's precisely what we did. It may not be possible, as you said, to have justice in the purest sense as we know it in the Western tradition, but we used this before European Western standards came to us, and we think we are still doing justice, fair justice, to the majority of cases.
Justice Abella, you have been an outstanding advocate for women, among others, in your court, as of course has Justice Beinisch been too, and some of the men on this panel as well. There are people who believe that we are compromising justice now in domestic courts in Canada and in the United States on behalf, for example, of women who have alleged that they are victims of rape, or African Americans who have alleged that they're victims of bias and discrimination. Is there any room, in your view, for imperfect justice as reparation and affirmative action for groups that have been victimized and discriminated against in the past, even if it means less justice for those accused, for example, of sexual assaults on women on college campuses, or harassment of people based on race? Or is there one standard of justice for all that should never be compromised if we have at least the ability not to compromise it? Is there a room for affirmative action in the justice system?
That's a two-part question, and let me answer the first one first. I am a believer in the Canadian notion of equality, which means, unlike the American notion of equality, it's not a Dyson model where everyone is treated the same. We acknowledge people's differences because we accept that sometimes those differences can be exclusionary, and so the goal is to make sure that people, notwithstanding differences, are included, get the same benefits, are entitled. So that's my view, first of all, about whether I think something like affirmative measures may be necessary when you've had historic disadvantage. I don't think there's any controversy in Canada about that as a concept. Your second question is, how does that play out in a courtroom? Well, the idea that a person would win a case because he or she is a representative of a particular minority group is so antithetical to what justice is all about that I don't think you'll find a Western judge who would agree that that plays at all into the analysis. The reason we have due process, as we did at Nuremberg, is that notwithstanding the most serious of crimes and allegations, the person charged is entitled to make full answer in defense. That's not a question of women's rights, minority rights. It's a question of a fair trial. And that, I mean, putting them together essentially assumes something about the global judiciary that I know that I haven't seen. So I just...
Well, we don't have time for a debate on this subject. I wish we did, because I think I would be able to persuade you that, at least on American college campuses today, that rule of a singular standard is not being complied with in many contexts. Indeed, under American law, a university can be punished if it applies due process standards in sexual assault cases. For example, if a university says that it wants to have a requirement of proof beyond a reasonable doubt, rather than a proof by a preponderance of the evidence, the university will lose federal funding.
It may surprise you how often some of the other countries in the world don't follow what the Americans do.
Thankfully. So thank you all for your amazing contribution and experience. I appreciate it very much.